Hi, thank you for joining our webinar. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Chad Michaelson, a Pennsylvania construction lien law guru. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Chad Michaelson.
Thank you very much, Jessie, and good morning, everybody. We have about 20 minutes here today to talk about strategies for making sure you get paid for the work that you provide. Before we get started, there are some instructions about the webinar here, particularly if you have a question, go to the webinar chat box there on the right, and at the end we'll check that and I'll try to answer any questions that you may have. So there are three things I want to try to talk about in terms of protecting your right to payment. The first is to read the contract, to know what's in your contract, and we'll talk about what to look for. The second is to actually follow those things and to comply with the contract during the project to make sure that you're doing all the things you need to do to not waive your rights to payment or jeopardize your rights to payment. And finally, what do you need to do when you're not paid? How do you protect your rights? So we'll start first with thinking about what do I need to look for in the contract? And you know, a lot of folks think that they should just sign the contract and get the work done, especially subcontractors and suppliers. You know, there sometimes isn't a lot of negotiating power, or you figure it's just not worth it, or we'll figure it out at the end. But what I like to tell people is you really do at the beginning have two choices. You can either negotiate or you can litigate. You can either discuss something up front, come to an understanding with your contractor or your owner, as to how you're going to handle something, or you can ignore it and get down to work, and then when the problem arises, you don't have an understanding and you're going to unfortunately end up litigating. So negotiating is the preferable path. So the first thing, when you look at the contract and read the contract, the things you want to talk to the owner or the general contractor about is about what is required for approval of payment, okay? The first thing I tell folks is do not agree that the owner, that the work will be acceptable in the owner's discretion, or that the work will be reasonably satisfactory to the owner or to the general contractor. The work should be performed in accordance with the contract documents. And once that's done, you should be entitled to payment. But a lot of contracts say you'll be entitled to payment if the owner is satisfied with the work, and that's not a good position to be in. Second thing is to pay attention to lender requirements, both in terms of the timing of how that might delay the payments to you, as well as anything that you actually have to include in your payment applications to satisfy the lender. You're always going to be required to submit lien waivers, but sometimes the lenders have other requirements. And you should look closely at those too. I mean, general contractors are often asked to sign documents with the lender that allow them that allow their contract to be assigned to the lender, and that's not something you should sign without really looking at it and thinking about it, or asking a construction lawyer to take a look. Second is look at the timing of payment in your contract. Obviously, timing is important for your cash flow purposes, but equally important to the timing is the pay if paid versus pay when paid scenario, right? And the pay when paid is far preferable because that entitles you to payment. That's just a method of timing. But the pay if paid means that you assume the risk that the owner's not going to pay. And the contract language will say that very clearly, that you're supposed to price in the risk of the owner's non-payment, and that if the owner doesn't pay for your work, you won't get paid for your work. So the pay when paid, if it just says you'll get paid within 10 days after they get, you know, the higher tier contractor gets paid from the owner, that's fine. Pay if paid is a different story. Look closely at retainage. You have to think about what they're holding retainage on. Is retainage being held on things like your general conditions or your insurance and bond costs, right? In order to help your cash flow, you want as little retainage as possible. And so you should negotiate up front as opposed to a flat 10% or 5% or whatever it might be that you only withhold retainage on items of work. And the other thing is, if you're an early work contractor, you want that retainage release. If you're the site work contractor, for instance, you're done with your work well before project completion. If you sign a subcontract that says you get your retainage when the whole project's complete, when the owner releases it, then you're sitting there funding that amount of money for a long, long time. You should negotiate a right to get your retainage when your work is done and when your work is accepted from the owner. Look at what the contract says about your lien rights. Most subcontracts I see will try to force contractors to waive lien rights. In Pennsylvania, a waiver is ineffective unless it is in exchange for payment received. So Pennsylvania doesn't allow advance waivers of lien rights except for one situation, which I'll talk about in a second. And what that means is that a general contractor can never be asked to waive its lien rights unless it's been paid, and then you sign a periodic lien waiver. A subcontractor cannot be asked to waive its lien rights unless there is a payment bond posted. And if the general contractor posts a payment bond and then files in that county, files of record, a notice of the payment bond and a notice of waiver of liens, then that filing can, in fact, waive a subcontractor's right or a supplier's right to file a lien. Instead, they are limited to pursuing a claim against the payment bond. So you need to know whether this project is a no lien project, whether there's a bond in place, and if there is, you should get a copy of the bond up front. It's sometimes hard to get a copy of the bond when you're not being paid. It's much easier to get it up front when there are no problems and it's a reasonable request. Second thing to watch for in terms of lien rights is whether your project is a quote unquote searchable project. And a searchable project is a project valued at over $1.5 million that the owner has filed with the Pennsylvania State Construction Notices Directory. So you can go to that website and search for your project and see if it's on there, but the law requires that it be listed in the contract as well. So when you see that, that means that you, as a sub, must file a notice of furnishing in order to protect your lien rights. If you fail to do so, you will waive your lien rights. And if you delay in doing so, then your lien rights will be limited to the services you provided within a reasonable time after your notice. You will lose the right to lien, maybe older amounts due or amounts due for work that you performed long before you filed your notice of furnishing. Finally, look for the changes clause, both in terms of changes to the schedule, changes to the scope. The subcontracts will often waive a subcontractor's right to certain kinds of compensation. Maybe it waives the right to any delay damages or impact damages or loss of productivity. So you have to watch for those things to make sure that you actually aren't waiving the right to get paid for extra work. After you have read the contract, negotiated these points, you have an understanding on these points with whoever you're contracting with, the next thing to do is to go get the work done, but do that in a way that follows the contract. So in other words, you've got to dot the I's and cross the T's. So first, think about your applications for payment and put some time into that. The pencil copy process is useful. It avoids the rejection of payment applications, which just gives the owner an excuse to hold your money for longer. So, submitting a quick payment application that you haven't thought about or that you haven't communicated with the engineer or with your general contractor about can be problematic. So spend some time on those and make sure you're doing everything that's required. Make sure you're providing all the supporting documents. And that's something to think about when you enter into the contract too, right? The contract should say what's required with your application for payment. If the owner asks you for more and it doesn't say anything in the contract, you can say, look, you can't reject my payment application because the contract didn't say I have to provide this stuff. But some contracts just say the application for payment will be supported by whatever documents the owner requires. And if that's the case, it gives the owner a lot of ability to hold up your payments and ask you for more. Keep in mind that if there is an error in your payment application, Pennsylvania's Contractor and Subcontractor Payment Act says that written notice of any error in an application for payment or an invoice has to be provided within 10 days. If the owner or the general contractor doesn't give you written notice of an error in your invoice within 10 days, then any claim of such an error is waived. So 10 days for written notice of errors. After that, the owner is not entitled to withhold. And the other thing behind the notice of errors is that, well, the reason it's 10 days is because obviously they want a proper payment application in, and that's when the clock starts ticking on payment. Look at your conditional lien waivers that you're required to submit. As I said, those are effective. A conditional lien waiver is effective when you're paid. So when you get a lien waiver that says, in consideration for the payment I'm about to receive, that's effective. If a lien waiver says, if you file a lien waiver before you get paid, in other words, with the payment application, that's not going to be effective until the payment is received because of the way Pennsylvania's lien law reads. But people do get hung up on whether the lien waivers are conditional or not, conditioned on payment or not conditioned. Think about whether you have pending claims as well, right? Your lien waivers are going to be broad. What they give you will not just waive the right to lien, but it might say you release any claims that relate to the work for which you're being paid. So at some point, by signing those, if you go back and you realize that you had impacts throughout the project, or you had changes that you're still negotiating, you could waive those. So you really want to be careful about filing lien waivers that release rights during the project. It's certainly okay to waive lien rights to the extent that you've been paid, but releasing claims is a different story. So then think about follow the contract in terms of processing a payment. Now this, if you're a general paying subs, you have 10 days to make that payment once it's received. If you're a owner making payment, you have 14 days. But CASPA, our Contractor and Subcontractor Payment Act, says that that's only in the absence of a different term in the contract. So what really matters is what your contract says. If the CASPA says that you have to be paid in 14 days, but your contract says 30, then it's 30. So look at those things. And then when you're having your payment processed, when that pay app is in, if the pay app is properly supported and accepted, but there are deficiency items, defective work, rework, or other reasons that the owner is going to withhold money that you would otherwise be due, they have to give written notice of that withholding within 14 days. So you, again, just like giving written notice of an error is required within 10, if they're not going to pay you all the pay app, they have to tell you why, and they have to tell you what that good faith dispute is, that withholding is for, in writing within 14 days, and they have to pay the rest. So the owner cannot sit on an entire payment application just because they want to withhold a portion of it for some reason. Finally, keep in mind under the contract the notice of claims and how you have to give notice of claims. This again relates to that idea that you don't want to sign a lien waiver to release your claims, but private claims, private projects, the contract will tell you you must give us notice within 7 or 10 or 14 or 30 days. Public contracts are even more important to follow notice requirements, because on public contracts there is case law in Pennsylvania that says that you cannot, as a contractor, rely on what the engineer or any other owner's rep tells you. The only way that you can actually be assured of payment for extra work is to have a change order signed and executed by the municipality or the government unit, which typically means you've got to wait until the Board of Supervisors meets and approves a change order. And that's not great for the progress of a project, but it's a risk for subs and contractors on public projects. And so it's something to keep in mind. Finally, when you get to the point where you're not getting paid, what do you do to protect your rights? So when it's slow payment, you look at your remedies under CASPA, right? CASPA says, as I noted, you pay in accordance with the contract, or the owner has, if your contract doesn't say anything, the owner's got 20 days to make payment from receipt of a proper payment application. And the contractor then, when it receives payment from the owner, has 14 days. Think about when you have change order disputes that are slowing down the payment process. You need to make sure the owner's aware that they're required to pay undisputed amounts. Don't let change order disputes sit out there and prevent you from getting your money when there's only a dispute about a small portion of that. So know your rights when it comes to getting paid for changed work. Also, retainage is an issue. CASPA says that retainage has to be released 30 days after final payment. Most contracts will release it at substantial completion, but again, depending on the nature of your work, you need to negotiate in your contract when that retainage comes out, and you need to enforce it. If the owner is slow to release retainage to you without justification, then you have rights and remedies under CASPA, and you should be pushing the owner and notifying the owner or the general contractor that they've got legal obligations to release that money in a timely fashion. So when it comes to slow payment, the squeaky wheel gets the grease. And so raising these issues and letting everybody know that you know your rights and can enforce your rights is sometimes the best way to speed up the payment process. And last but not least would be the sort of ultimate remedy, which is that your ability to file a lien or to file bond claims. Your timing to file a lien in Pennsylvania is 6 months from the date of last work performed. That is the last scope work. That's not warranty work or minor punch list work. It's typically when you reach substantial completion, that would be the date in which you have 6 months to file a lien. But importantly, if you are anyone other than the general contractor, if you do not have a contract directly with the owner, you have to give a preliminary notice in order to file your lien. And that has to be done 30 days before you file your lien, which means that effectively subcontractors and suppliers in Pennsylvania only have 5 months, because at the end of that month 5, after the end of that 5th month, you need to provide your preliminary notice of intent to lien to the owner and the general contractor. And then 30 days after you've provided that notice of intent to lien, you can file your lien. So those timeframes can get really tight. And if you're a sub or supplier, do not wait until the end of the 5th month to call SunRay or to do what you need to do to get those notices in. You need to think about this in advance. You should probably tell yourself that I only have 3 or 4 or 5 months to file a lien, so you don't get jammed up in trying to prepare the proper notices and get them to the right people within the timeframes required. If you miss those timeframes, you're out of luck. Finally, bond claims. This is extremely important. Bonds have similar timing requirements. Some bonds on public projects would require you to bring suit within a year after the claim arises or the non-payment arises. So you need to look at the bond. You need to look at the bond not only for timing, but for what it is that you need to submit. If you don't make a proper bond claim, it's either going to be rejected or it's going to delay the processing. So you look at the bond, the language of the bond will tell you exactly what a claimant must submit and what your rights are under the bond. And you need to submit those in a timely fashion in order to make sure that you don't waive any of your rights under the payment bond that would be posted, and replace your rights to file a lien. So those are sort of some highlights, I think, some tips for how to ensure payment. Obviously, every project's a little different, and there are lots of nuances to that, but hopefully that's helpful and will help you all get through your jobs and get paid a little faster.
Well, thank you so much, Chad. That was a great webinar, packed full of little nuggets of information for us. We do actually have a question that came through to me. It says, can attorney's fees and filing fees be included in my lien amount?
Oh, that's such a great question. Okay, the answer, unfortunately, is no. All right, a lien only covers labor and materials in Pennsylvania. However, CASPA says that if you have to sue in order to get paid, and you substantially, and you're the prevailing party in that, then you can get attorney's fees and interest. So practically what we would do is we would file a lien, and then if the lien doesn't get you paid, we would file a complaint to enforce the lien. That would be a lawsuit to collect only the amount of the lien. At the same time, unfortunately, we have to file a separate lawsuit, and that separate lawsuit would have a CASPA claim, and it would be your breach of contract claims, and that would include your attorney's fees and anything else that you couldn't get in the lien claim. So it's a little cumbersome, but that's the way you have to do it. And the answer to your question is no, you can't include any of those CASPA remedies, attorney's fees, interest. You cannot include those in a lien.
Okay, well, thanks for addressing that and letting us know that there might be a different route to kind of take to eventually get that. All right, and then how long is my lien effective for?
Oh, good question. So it is effective for a significant period of time. You must move to enforce a lien, meaning you have to file a complaint, file a lawsuit on the lien. And you're going to test my memory, and I believe it's 2 years. All right, I'm probably going to have to go check that after this to make sure. But it is a significant amount of time. So the lien can remain in place while you try to negotiate. But typically, if you're not going to be paid, if you've had a lien out there for 6 months or something and you're not getting paid, it's time to file the lawsuit because the lien's not enough. So the time frame is certainly more than a year. I think it's 2, and you caught me on a good question. I'll have to look at it.
That's so funny. Well, thank you so much. All right, now that seems to be all the questions that have been posed. If anyone does think of a question that wasn't addressed, please feel free to reach out and we will be sure to answer any questions for you as soon as possible. Can you go ahead and go to the next slide for me? So who is ready to win a gift? We are testing your knowledge. If you can answer these questions correctly in the chat or the questions field, we will go ahead and send you guys a little prize, a little gift for you. So here are the questions. In Pennsylvania, if a project exceeds $1.5 million and a notice of commencement is filed with the state construction notices directory, subcontractors and suppliers are required to send a notice of furnishing within how many days to preserve their lien rights? And then the next question is, when is the deadline to file a Pennsylvania mechanics lien claim if I'm a subcontractor? So go ahead and take a look at those. If you feel like you know those answers, go ahead and put them in that chat for us so we can send you guys over a gift. All right, go ahead and go to the next one for me, please. Perfect. All right, so here are some of the SunRay resources to help you stay organized, know your deadlines, secure your lien rights, and so many more. So go ahead and scan that QR code to access these incredible resources.
Hey, Jesse, can I interrupt you?
Yes, of course.
It's 2 years. I guessed right.
Perfect. Thanks so much for double checking that for us, Chad.
Yep,
All right. Go ahead and go to the next slide for me, please. All right, so we have a new service that we are offering at SunRay. We have SR receivables. We're going to be helping you to handle your collections for you, and we are here to help get you guys paid. So if you're interested, go ahead and check it out. Send us over an email or give us a call, and we'd love to help you. All right, now Chad's next webinar is going to be on Tuesday, July 16th at 9:30 a.m. Eastern Time. It's getting paid faster with liens, bonds, and contracts. So please make sure that you guys go ahead and register for free at sunraynotice.com/education. We'd love to be able to see you guys there. All right, go ahead and go to the next one for me. All right, this one, please take a moment to review us on Google. We would really appreciate it. It takes about a minute of your time. Go ahead and scan that QR code. You can give us a review. We appreciate all the feedback, and it helps to get this information out to more contractors like yourselves. All right, go ahead and go to the next one for me, please. Perfect. And then with that, that is all we have for you guys today. Thank you so much for everyone that attended. We hope to see you guys at our next webinar. And thank you again, Chad. You were incredible, and I hope you all have a wonderful and sunny day. Thanks again. Bye-bye.